Hello everyone and welcome back to further in the lecture series for the preparation of CLAT examination. In this particular lecture series, we are actually discussing about the important aspects of the legal reasoning portions when you talk about CLAT examinations as such. We've been dealing with all the important legislations that has often been asked in your CLAT examination, specifically talking about the legal reasoning portion. So we have completed a lot of areas when we started with this particular lecture series. We have completed the law of torts, the criminal laws, the constitutional laws, and then after completing all these important legislations, we moved towards the family laws. We've started the family laws with the sources of both the Hindu as well as the Muslim laws, and post that we completed the marriage under the Hindu laws. So there is a codified law which is known as the Hindu Marriage Act of 1955, which tells us that what are the important requisites one needs to fulfill when we are supposed to marry between two Hindus. And then after that, we started with the succession of under the Hindus. The succession means that once a person has died, leaving behind no will of his own, then how the property will be segregated among its legal heirs, that is what we were supposed to discuss. Because these type of questions are also asked that if a person dies without leaving any will, then who is going to inherit his property? So that is what we were discussing in our previous lecture series. If you remember, we had discussed about the general rules of succession in case of males, that how the male will be provided the successions. So specifically talking that the first and the foremost thing that you need to understand when we talk about the successions as such, that is that how the property will be segregated among the people, among the inheritors. So for that, we have the schedules that incorporates that there are two type of hires, one being class 1 hires and other being the class 2 hires. And it is for both the males as well as the females. Here specifically, if you talk about CLAT examination, the question that will be put up in front of you is majority will be in relation to that if there are 3 people, then who will survive and obviously who will inherit the property. So in order to understand, we are not supposed to go through each and every sections of the Hindu Succession Act. Specifically talking, we will be confining ourselves to the major sections of this particular legislation, because that is more than sufficient for your CLAT examinations as of now. So when we talk about Hindu person who has died intestate, in the previous lecture series, we discussed about that if a person dies without leaving his will, if a person has left a will and the will is registered and it follows all the provisions that has been mentioned under the testimony succession, that is section 31 of the Hindu Succession Act. I'll just show it to you also if that will be feasible for you. If you can see the screen, guys. See, so when we talk about testamentary succession, it has clearly mentioned that if any Hindu may dispose of by will. Okay, so by will. Now, what is will? Question is, what is will? The will is, it is a piece of a document which contains all the narrations of the property, whatsoever property the person has acquired throughout his lifetime, and then the person mentions those properties, and then eventually there he puts up his signature, and then there are 2 witnesses in whose presence he has or she has made that particular will. After signing the document, the person, the witness who are present there, they will also sign that particular property, a particular piece of document. And this will is considered as a piece of document, or which is considered to be a dying declaration. A person before dying has provided an information that after my death, by whom my property will be owned. So that will is the basis through which a person voluntarily, without any influence or without any force, makes a piece of document which is known as will, which describes that who and how the property will be disposed. So any Hindu may dispose of by will or other testamentary disposition any property which is capable of being so disposed by him or her in accordance with the provisions of the Hindu Succession Act and or any other law for the time being in force and applicable to Hindus. And then it suggests that the interests of the male Hindu in a Mitakshara co-personary property or the interest of members of these tribal areas, shall, notwithstanding anything contained in this act or in any other law for the time being in force, be deemed to be property capable of being disposed by him or her within the meaning of this section. But when we talk about testamentary succession, it is clearly saying that if a will is present, any Hindu may dispose of by will or testamentary disposition any property which is capable of being so disposed in according to the provisions of the Hindu Succession Act of 1925, Indian Succession Act of 1925, that property can be devolved. So in the Indian Succession Act clearly mentions that if a person, if he makes a will and that will has been made in the presence of two witnesses, and that two witness has provided their signature over the same, that will is valid. Now the question comes up in front of the students and the CLAT aspirants, that is whether a will, if it is made and if it is not registered, the will is not registered, then whether that will be considered to be a valid document to dispose of a property. For example, let's take an example for a better understanding. There is a one person X, This person has three properties and he dies mentioning that Y will be the rightful owner of all these property after my demise. So now, if X has mentioned that all these three properties will go to Y, whether that only this particular piece of document will be sufficient enough to prove that now the owner of the property which belonged to X has now been made to Y. So in order to ensure that there is no loophole left and there is no problem in enforcing that particular will, it is always recommended that the will should be registered, because once the will is registered, it is known in the eyes of the authorities that there is a will that has been created and that will has been registered. So it will have more power. But it is not like that if the will is not registered, it is not enforceable. The will is very much enforceable even if the will is not registered. There are Supreme Court judgments which has clearly mentioned that even if the will is not registered, it cannot be invalidated. It will still be enforceable. But if the will is not registered, then we will have to approach to the court and we will have to get the authenticity of that particular will. So we will provide the documents, and eventually after the due diligence and investigation, the court will provide an order where which it will mention that the will is a registered, it is a valid will and it can be made enforceable. And once you get that particular document, it will be easier for you to get the will enforced. So that is something which is known as testamentary succession, which we have already discussed in our previous lecture series. Now, here we are talking about those areas where which if a person dies without leaving any will. Now, if the will is not present, if the person has not made the will, then how the property will be devolved, it has been mentioned under this particular legislation, specifically starting from section 8 of the rules of succession in case of males. Now, let's take an example. A person dies without leaving behind any sort of will. And now that particular person has owned 3 or 4 properties. Then how that all the property will be devolved has been mentioned under section 8, 9, 10 and different provisions of in this Hindu Succession and Adoption Act. Hindu Succession Act of 1956. So in order to understand that, first let's understand what does that particular section 8 is talking about. So if you see here that section 8 is talking about the general rules. What are the general rules? That is something that we need to understand. The property of a Hindu male dying intestate. Intestate means without any will. Without any will. Shall devolve according to the provision of this chapter. Now, what does this chapter says? This chapter says firstly upon the heirs being the relatives specified in class 1 of the schedule. Now it is saying that the first and the foremost, the property of the person who has died intestate shall devolve to the relatives that has been specified under class 1 of the schedule. Now class 1 of the schedule, class 1 of the schedule has provided different relatives who will be allotted same share if the person who has died does not have a will. Now, if we see the schedule, if we see the schedule of class 1, this is the schedule, and under class 1 there are different narratives. Now, it obviously will become difficult for you people to understand that what exactly this particular schedule is talking about. So for your better understanding, I will just mark those things down. But before that, yes. So I would like to explain to you in a very simple manner that who all will be provided this property if a person dies intestate without leaving any will in regards to the males. So if we talk about males, the first thing that you need to understand is that there are different classes of heirs. One being class 1 heir, then it will be class 2 heirs, then it will be agnates, and then it will be cognates. And after cognates, it is escheat. Escheat means that all these heirs, whatsoever has been there, has not been present. Neither class 1 heir is there, class 2 heir is also not there, agnates are not there, escheats, cognates are also there. Then the property will go to the government, and that is what is known as escheat. But first we need to understand that what exactly class 1 heir means here. That who all falls within the category of class 1 heirs. Now, the legislation suggests that class 1 heir has been mentioned under the schedules. And in that particular schedule, there are different names that has been mentioned. And there are total of, for your better understanding, there are total of 17 relatives to whom the property shall be devolved under class 1 heirs. Now, if I'll try to explain it to you, that if the class 1 heirs are present, okay, if the class 1 heirs are present, then the property will be devolved to only class 1 heir, irrespective of the fact that class 2 heirs, class 3 heirs, class 4 heirs are also present. And class 3 and class 4 heirs, specifically the agnates and the cognates, are present. But if class 1 heirs, any member that has been mentioned in the class 1 hires are not present, then only it will devolve to class 2 hires. And in class 2 hires, again we will understand that how the property will be devolved. But for your understanding, let's try to understand who all will come under class 2, class 1 hires. Now class 1 hires, let's take this one. Okay. Now there is a person P. Okay. Let's take the example that there is a person P. Now this person P has died, leaving behind properties. Now this particular property needs to be divided into the different people who has been present there, that who also are the relatives that will claim their property. So now the Hindu Succession Act of 1950 says that there will be total of 16 relatives. The first and the foremost we'll have to understand here that if the person dies and he has a mother, okay, and he had a widow, okay, and after that, not only widows, okay, let me do one thing. Let me just make this diagram a little bit upper side so that it becomes clearer for you to understand. Okay. So there is a person P who has died and he had a mother alive. Then there is a widow. And apart from that, he has a father also. Okay. Apart from that, he had a son. Then let's take an example that he had another son who has died. One more son was present who also had died. Then he had a daughter. Then another daughter who died and another daughter who died. So this example is just for your better understanding. It is not like that for everybody. You will imagine that, okay, there will be 3 daughters and 3 sons. It is just for your better understanding. I am making you, I'm just giving you a pictorial representation. And then the second son got married, and after his demise, he had a son. This is son means that the person who has died also had a son and a daughter and a widow. Okay, the widow. Then, and this son who died also had a son and a daughter. The son and the daughter also died for this person. Okay. But this son also had a son. Okay, this is son's son, means this son's son, and he had a widow and he had a daughter also. And this daughter who was supposed to be died also had a daughter. Okay. Now when we come to the daughter's side, if we come to the daughter's side, let's take this example. The second daughter had a son and a daughter. And this had also So now if you see this diagram, you must be a little bit confused at what exactly we are trying to understand here. I am trying to make you people understand that these 16 relatives shall include all the numbers which I am going to mark it right away, so for your better understanding. So if a person dies leaving behind intestate, and if any of the members whomsoever has been mentioned here in this particular diagram is present, then the property shall be devolved to these relatives only. For example, if this particular person P has died and he has a mother, the property will be given to mother. This is the first one. Whether the property will be also given to the father? No. Father doesn't fall under the category of class 1 highest. So mother will get. Now, the property, if widow is present, the wife of the deceased is present, the property shall also be given to the wife. If a son is present, then the son will also get the property. If a daughter is present, then the daughter will also get the property. Okay? By the Amendment Act of 2005, daughter are also entitled to property. Now, the son will get, the daughter will get. But if, suppose, son of the deceased is also deceased, means son has died and the father has also died. The father means the person to whom we are referring as the main person, whose property is an issue. Then, if that son who has died has survived by a son or a daughter, they will also get the property. Okay? 5, 6. And if the wife of the predeceased son, meaning which, if before the demise of the person P, his son died. Before the demise of P, his son died. And when the son died, the son had a son. This predeceased son was survived by a son, a daughter, and his wife. All these 3 members shall also be entitled to property. So first is mother, second is widow, third is son, fourth is daughter, fifth is son's son, meaning which the son who had died before, leaving behind a son and a daughter and a wife, all these 3 shall also be entitled to property. Then, if the son, the predeceased son has also died. Okay, so this son has also died. Taking this thing example, but he was survived by his son, widow, and daughter. Then these people shall also be given the property. So these people will also be entitled to be under the class 1 highest, and they will also be given the property. If we talk about a deceased daughter, a daughter that was there, but she died. But before her demise, she married and she got a son and a daughter. These 2 survivors of the daughter shall also be entitled to the property which belonged to P. And then, if the son of a predeceased son. Of a predeceased son. So this is the son of a predeceased son. Of a predeceased son has survived at the time of the demise of P. Then he will also be entitled to the property of P. Same goes with the widow of the predeceased son of the predeceased son and the daughter of the predeceased son of the predeceased son. If we talk about the daughter of the predeceased daughter of the predeceased son, she will also be entitled to the property. In the same manner, if a daughter has been survived of a predeceased son of a predeceased daughter, then she will also be entitled to the property. And if a predeceased daughter has survived by a daughter who happens to get married, and after that this is predeceased, and if after her demise she was survived by a son and a daughter, they will be also entitled to the property. Now, if you see that there are totals of 16 members who eventually, if they are present, then the property will be given to them. Let's now understand that if this son who is surviving, and at the time of his survival, he also got married, and at that point of time he had a wife, a son and a daughter. So these three shall not be entitled to the property of P. Reason being, the son of P is still alive. So although the son can get the property, but the widow or the wife of the son of the surviving son and the daughter of the surviving son, they cannot claim property until unless the son of the deceased has died. So these three people, even though if they are present, they cannot claim any interest in the property of P. But if the son dies before the demise of the person to whom all the property belonged, if the son dies before the death of the person, then these three people, the widow, the son and the daughter, the son, the widow and the daughter shall be entitled to that particular property. Now assume that the son of a predeceased son. Okay, so now this is the person P who happened to have a son who died, and from that son there was another offspring, and that was the son, which happened to die also, and he was leaving behind another son, wife and daughter. So all these three people shall also be entitled to the property of P. Had this son been alive, these three members would have not got the property of P, because if the son has alive, then the son will take the property of P of the predeceased son, but not the surviving members. So it is important to understand that the property shall be given to the deceased, shall be given to the offspring of the deceased only if he has died or she has died before the death of the person concerned. For example, X dies leaving behind one son, and there was a daughter which died before the death of X, and from that daughter there was a son, and there was a daughter. And from this particular son, the son who is still alive, he also had the son and a daughter. Now the question is, out of these 4 people, who is entitled to the property of X? The answer is S, who is the rightful son of X, will be entitled to the property of X. But if you remember, the daughter shall also be given the property, but the daughter has died. Then who shall take the property that should have been given to the daughter had she been alive? That property will be again subdivided between the son and the daughter of the predeceased daughter. So the daughter, although she is not present, but the property, if these 2 members are present, they will get the share what the daughter would have got if she would have been alive. So in this manner, the daughter and son will, if the property of X is 1 portion, then it will be divided between 2 people, son and daughter. So son will get half of the property, daughter will get half of the property. But the daughter is not alive. The daughter is not alive. Then this half share, if the daughter who is not alive was survived, meaning which before the death of X, daughter got married, and after the death, before the death of X, daughter got married, and after the marriage, she got a son and a daughter. And after a certain point of time, the daughter died. Then the son and the daughter of the daughter who has died of X will be entitled to get the property which belonged to X by virtue of being the offsprings of the daughter of X. So meaning which these 2 people, the son and the daughter of the predeceased daughter, will get half of these 2 people will get half share of the half share which the daughter would have got if she would have been alive. So the half share will further be subdivided into half and half, which will be given to the son and the daughter. So in the same way, the property shall be segregated among the offsprings if the offsprings has if the father has survived the son and son has died, and then before the death of the son got married, and after the marriage he had a daughter, a wife and a son. The son, daughter and wife shall be given the property had the person died before the death of the person who is in concern. So there are total of 16. There are total of 16 relatives. First being the mother, second being the widow, then the son, then the daughter, then the son's son, son's widow, son's daughter. And if son has also died, daughter has also died, then the property will be given to son's wife, son's daughter. So this particular diagram is enabling to understand that all these 16 people, if any of them are present, if any one of them are present, then all the remaining class of heirs, that is class 2 heirs, agnates and cognates, shall not be entitled to any share in the property which belong to P. So now let's try to understand that, for example, son is present, daughter is present. Then all these people, even if they are present, they shall not be entitled to any property. The property will be divided between the son and daughter who is present. But if son dies, leaving behind any son, daughter and widow, then they will be entitled to the property which actually would have gone to S. Only that share will be further subdivided into these three people. So for your better understanding, what you can understand is that if a person P has died, leaving behind a son and a daughter, then the property will be divided into the mother, the widow, the son and the daughter only. That's it. But if the son or the daughter or the deceased, if the mother dies, then the property will be only segregated between the widow, the son and the daughter. If the son dies and son has no offsprings, then the whole property will be divided between the mother, the widow and the daughter. If the daughter dies, leaving behind son, if the person dies and he has the son, the wife and the mother, then the property will be only given to these three people, not to the offsprings. But if the person has not died, if the person is still alive, then the property will only be given to that particular person, not to the offsprings. So that is how the class 1 hires, that is the 16 people, 16 persons, if present, if any one of them are present, then the property will be divided, it will be given to that particular person. If more than one person is present, then according to the line of ascent, they will be given. Let's try to understand it again so that it becomes very clear to you, because that is perhaps very important for your better understanding. Because once you understand it, then majority of the things in regarding to the succession is over. So first thing, that there was a person P, okay? He dies and he had a mother, a father, a widow, he got married, and there were son and daughter only. Now let's try to understand in a very systematic manner. So the property that will be provided according to class 1 hire. Class 1 hire, who all are there? Mother is there? Yes, mother is there. Widow is there? Yes, widow is there. Son and daughter is there? Yes, son and the daughter is there. Then how the property is going to be divided? First, we need to understand what are the rules. Rule says, what are the rules? Those in class 1 shall take simultaneously and to the exclusion of all other hires, those in the first entry in class 2 shall be preferred to the second entry. Okay. So what is the rule of distribution among the class 1 hires? That has been mentioned the section 10 of the property. Now what does this say? The property of an intestate shall be divided among the hires in class 1 of the schedule in accordance with the following rules. And what is this rule? The intestates means the person P, to whom we were referring to, widows, okay, intestates widow, or if there are more widows than one, all the widows together shall take one share. Okay. The surviving sons and daughters and the mothers of the intestate shall each take one share. Okay. The heirs in the branch of each predeceased son or each predeceased daughter of the intestate shall take between them one share. The distribution of the share referred to in Rule 3 among the heirs in the branch of the predeceased son shall be so made that his widow and the surviving sons and the daughters get equal portion and the branch of the predeceased sons get the same portions. Okay. Among the heirs in the branch of the predeceased daughter shall be so made that the surviving sons and the daughters get equal portion. Okay. Now, again, for your better understanding, now the mother will get one share, that is clear. The wife will get one share, that is clear. Son will get one share and daughter will get one share. So all these 4 members will get the share. But since father is not included under class 1 higher, he shall not be entitled to the shares that the P have acquired during his lifetime. Now, let's assume that the daughter of the deceased, of the person, died before the death of P. And before the death of the daughter, she was survived by a son, daughter's son, and daughter's daughter. Then these 2 shall also be entitled to the share that daughter would have got. But that share will be divided into 2 portions. Which will be divided into 2 portions. Half will be given to the son and half will be given to the daughter. Then this is the way the property will be divided. So the property, if daughter would have not been present, it would have gone to the mother, 1 share, widow, 2nd share, 3rd share gone to the son, 4th share gone to the daughter. But the daughter is not present. Then the share that the daughter would have got would be devolving between the surviving son and the daughter. And if there would have been 2 daughters, and 1 son, then the property would have been divided into the same property which the daughter would have got will be equally divided among the descendants of the predeceased daughter. Okay. In the same manner, if son dies leaving behind a son, a widow, and a daughter, and if we now have to see that how the property will be divided, the property will be going, 1 share will be going to the mother, 2nd to the widow, 3rd share to the daughter, and the 4th share, which the son would have got had he been alive, shall be divided between his surviving son, widow, and the daughter. So, if the son, would have got X share, then this X share would be divided between these 3 people in such a manner that all these 3 will get equal shares. Okay, understood? Now, moving forward. Now, let's take the example that in a particular hypothetical situation, the son died. Before his demise, he married and he had a daughter and a wife. Okay. It happened that the daughter had another daughter, but this daughter died. So the property will be divided again. This person will get what share? Let's take the example. This share will be X. So the daughter will get X divided by 2 and the widow will be getting the share X divided by 2. Now this daughter died leaving behind another daughter. This daughter shall claim the whole share of this daughter because she has survived her mother and her grandfather. So she will be entitled to the property because she is under the class 1 hires. So this is how it is important for you to understand that who shall all be getting the property under class 1 hires. So any members who are present under the class 1 hires shall be entitled to the property that has been mentioned. Here we need to mention one more thing which is important, and that is that the son shall include illegitimate son also, and it also include illegitimate son. It also includes daughter, which includes illegitimate daughter, and adopted daughter. So this is an important thing that you need to remember, that according to section 10, that each survival to get equal share is important to understand that who will be getting that more property. Now, if we talk about class 2 hires, class 1 hire is clear. Class 1 hire claims that there will be a total of how many members? There will be a total of 16 members. But now if we talk about class 2 hires, if we talk about class 2 hires, class 2 hires has total of 9 categories. Class 2 hires has a total of 9 categories, and presence of any one category will exclude the remaining category from claiming or inheriting the property of the deceased. And this is important for you to understand, that class 2 hires shall only come into play when class 1 hires are not present. If any of the members of the class 1 hire is present, then the property shall devolve to those persons, not to class 2 hires, not to class 2 hires. It is important because perhaps students get confused that if the property is present and there is only one person present, is it possible to transfer the property to the husband or to the father? First, we need to understand that the 9 categories that has been mentioned, the first category talks about the first category in regards to a male who has died and there is no class 1 hire present. Then the property, the first person that the property will be divided is the father. If the father is present, then all the remaining 8 categories, all the remaining 8 categories mentioned under class 2 hires that has been mentioned under the schedule shall be excluded from inheriting the property, and all the property shall devolve to the father. But if the father is not present, then the property shall be devolved between the siblings, that is the brothers and sisters. And let's take the example that there is a brother who has died, okay, and he had a son, and then he had another daughter, and then from that daughter they had a son and a daughter. Then all these four members, number 1, number 2, number 3 and number 4, all these sons and daughter shall be given the property equally. Preference in brother and sister, full brothers and sister will inherit property, half blood shall inherit property afterwards. So that is something that you need to understand when you talk about class 2 hires. if the father is present, all the property shall devolve to the father, and if the father is not present, it will devolve to the sibling, that is to the brothers and the sisters. And the brothers and the sisters, if the brother has died, and if the brother has died, then the property of if it has been survived by a son and by a daughter, then equally the share will be given. In the third category, you will find mention of sons, daughters, son. Then you have daughter's son, daughter. Then you have daughter's son. The third one means daughter's daughter. So if these people are present, then they will, and if the father is not present and the brothers and sisters are not present, then the property shall be given to the daughter of the predeceased. Okay, if the person has died, then the property, and if it has been survived by the daughter's son, daughter, or the daughter's son, or daughter's daughter, then they will be acquiring that particular property. But if the fourth one, bro's son, bro's daughter, sister's son and sister's daughter can also acquire property if these peoples are not present. So bro's son, bro's daughter, then you have sister's son and sister's daughter. All these things, all the 9 categories we talk about has been clearly mentioned in the Schedule 2. We'll try to understand that what exactly Schedule 2 is talking about. Let's see. The first is the father. This is class 2 the first one is father. The father, if father is present, then the remaining people shall not be entitled to the property. But if the father is not present, then the son's daughter's son, okay, the son's daughter's son shall be entitled to the property. Then the son's daughter's daughter, brother and sister shall be entitled to the property. Son's daughter's daughter. So there was a person X whose son had a daughter, and that daughter had another daughter. So this daughter is entitled to the property of X if any of the members who have been mentioned before them has not been present. Neither the father is present nor the class 1 higher is present. And the same way, sons X had a son who had a daughter, and from that daughter he had a son. So this son can also claim the property of X if the father or class 1 higher is not present. Then only the son's daughter's son can claim the property, and the same way the son's daughter's daughter can claim the property, and then after that the brother and the sister can claim the property. Okay, when you talk about third category, it is talking about daughter's son's son. Okay, so the person X had a daughter who had another son, and that son had another son. So this son, the son of the predeceased son of the predeceased daughter, is entitled to the property of X if any members under the class 1 hires or any person who has been mentioned in the categories 1 and 2 is not present. Okay, so then third category will come into play and they will be entitled to inherit the property. In the same manner, sons, daughters, son. If the son is and the daughters are not present, the sons and daughters are not present, then it will devolve to the brothers and the sisters. First to the brother and then to the sisters. Daughter's son's son. daughter's son's daughter, and in the same manner, this property shall be devolved. Then to the brother's son, then the sister's son, then brother's daughter, then the sister's daughter. In the same manners, father's father, father's mother, father's widow, brother's widow, then father's brothers, then the father's sister. And after that, mother's father, mother's mother, mother's brothers, mother's sister. So, in this schedule, reference to the brother or sister does not include reference to a brother or sister by uterine blood. Uterine blood means from mother's side. Okay. So I suppose you are able to understand what exactly is class 1 higher and class 2 hires in regards to the inheritance of males when we talk about the general rule of succession in case of males. So who all will inherit the property and when they will inherit the property has been discussed in this particular lecture, so that it becomes clearly understandable that when and whom shall inherit the property. Now, after class 2 hires, we see that if the class 2 hires are also not present, then to whom the property shall be given. So if the class 2 hires are not present, then above 2 classes not, then upon the agnates of the deceased. So agnate means the persons who are related through male. Okay. If any person is related through the male descents, they can claim the property if any person present in class 1 and class 2 hires is not present. And if anyone is present in that particular manner, then the property will be given to them. If the agnates are also not present, then it will go to the cognates. That is any person who is related from the mother's side. Okay, that is clause D, which is talking about the order of succession. Okay, distribution of property we have just studied. Now, after understanding among the agnates and cognates, we will now try to understand that how the property of a female Hindu. We have understood the male Hindu, now we will try to understand how the property of the female Hindu shall be divided. And for that understanding, it is necessary that we go through the sessions and the successions under the general rules of successions under the Hindu male, section 8, which is specifically talking about the general rules of succession. Then section 9, which is talking about that how the preference shall be given. Section 10, which is describing that who all will be the members under the schedule 1 who can inherit the property and how the property shall be given. Then we have talked about section 11, which talks about class 2 hires. Then section 12, which talks about agnates and cognates. Section 13 we have not dealt with because section 13 is not actually important for you guys. This is computation of degrees. That is not important. Now we will be moving forward and we will be discussing about the properties of female Hindus. It will be an absolute property. So any property possessed by a female Hindu, whether acquired before or after the commencement of this act, shall be held to be her own as full owner thereof and not as limited owners. Okay. So the property which has been included, it will include both movable and movable property acquired by a female Hindu by inheritance or devise or at partition. So it can include inheritance or devise or at partition or in lieu of maintenance or areas of maintenance or by gift from any person. So all of this property will be called as a self-acquired property, whether a relative or not, before, at or after her marriage, or by her own skill or exertion, or by purpose or by prescription or in any other manner whatsoever. And also any such property held by her as Stridhan immediately before the commencement of this act. So the Stridhan is also something that can be claimed by the woman as their own property. That if they have been gifted something during the marriage, that will considered to be self-acquired Stridhan. So that Stridhan is also now the property of the female. So with this, we will, in the next lecture series, we'll start with the property of female Hindu, as how the property shall be divided in regards to the female Hindus. So from section 15, we'll start from the next lectures, in which we will understand just the way there were class 1 hires and class 2 hires. There is also this almost the same category, first upon the sons and the daughters. That includes any of the predeceased sons or daughters and the husband. Okay. Secondly, upon the hires of the husband. Thirdly, upon the mothers and the father. Fourthly, upon the hires of the father. Lastly, upon the hires of the mother. And this is how the property shall be segregated. Okay. Of the under section shall be and distribution of the intestate property among all those hires shall take place according to the following rules. Okay, so all these things in detail we'll understand, and we'll try to analyze that how the succession will actually take place in regards to the Hindu females. So with this, I would like to thank you all for being present here and for understanding that how the property under the Succession Act, specifically talking under the Hindu males, take place. With this, I would like to thank you all. Good night. Take care. Bye-bye.